You've thought of your mark, you've registered it, and now you are officially registered with the USPTO's office. Years later, you see that someone is using your mark without your consent. What happens next? This is the time that you enforce and protect your trademark. What does that look like? When you have trademark infringers, you have the ability to cause them to stop infringing on your mark. So what is a trademark infringement? A trademark infringement is the unauthorized use of your mark leading to consumer confusion. So in this case, how do you enforce your trademark? You have a variety of options. The first one is the standard cease and desist letters, where you acknowledge to that person or the infringer that the mark belongs to you and for them to stop using it for money. The other way is to flat out take them to court and litigate the issue. In litigation, the court will evaluate a factor of things: how similar the goods are, maybe the similarity of the names, the industry, maybe even the goods and services that you are rendering. And then after weighing all the different options, they will provide a legal opinion as to whether they get to continue to use the mark or if you are able to protect your mark and seize them from using your mark in commerce. Let's talk specifically about cease and desist letters. The cease and desist letter has to be well drafted by an attorney because there are certain elements that you want to see in a cease and desist letter to put the infringer on notice that you are serious about protecting your mark. For example, you want to be plain as day as to what you are requiring from them. Whether that means that you want to stop them from using the mark in totality, or you are inviting them to come to a negotiation with you where you can control how the mark is actually being used or how to get royalties for a certain amount of time that they use the mark. Now, sometimes this can be very tricky because you don't want the goodwill that you have built over the years to be watered down by someone that is just riding on this great name that you've made for yourself, the credibility that you've built with your consumers. What that can look like is where you allow the infringer to use your brand name for a while or your branding element that you've trademarked for a while. But because of poor customer service, poor quality in service or goods, it starts to tarnish your name. So before you think about actually negotiating into an agreement or licensing with an infringer, you want to spell out your requirements as to the quality and the standard of whatever goods or service that is going to be provided so that your clientele or your customers don't end up moving away from your brand because of low productivity. So what do you do when someone is infringing on your mark? Contact us. Let us help you draft that cease and desist letter or negotiate special terms so the infringer knows that you mean business. Lastly, when it comes to trademark renewal and maintenance, remember that the USPTO requires filings at the 5th to 6th year, the next 10 years, and every 10 years after that. If you are not quite sure where you stand, we are always readily available to help you.